Yes, Mr. President.
I'm obliged, Lord. I was going to deal next with the Supreme Court's order made following FIISC 3. And as we'll see, what's critical here is that the effect, both of the judgment and of the order, is that the interest rate that's applicable to what's called the period of prematurity, or the SEMPRA period, that's the rate set out in Section 85, Finance Act 2019, so not the higher, as it happens, compound interest rate that had been applied by agreement in the 2016 summary judgment order. What did not change was that the revenue remained liable to repay the time value computed on the Section 85 basis of ACT, which had been unduly levied under the FID regime. And that follows both from the terms of the order itself, but also, and importantly, from the scope of the grant of permission that the Supreme Court gave. We looked at the Supreme Court's order in opening, and I just want to recall a couple of paragraphs there, and then also to show you a passage in the judgment which explains the extent of the issue before the Supreme Court. So that's Supplementary Bundle, tab 9, starting at page 50. And we looked with learned friends, paragraphs 2 Roman 1, page 51, revenues appeal allowed on issue 10, relevantly limited to the SEMPRA issue. And then 26A, that was the more general question of should interest be simple or compound. And then paragraph 4 over the page 52, that's the setting aside to that extent only. And the to that extent only ties in, as we'll see, to the point about the appeal being limited to the SEMPRA issue. I don't think we looked at page 53, although the court probably has looked at this in preparation. That's where issue 10 is set out at the bottom of page 53. That's the question that's being addressed. When the court says it's limited to the SEMPRA issue, it's asking should interest be simple or compound, in particular on what basis can the claimants recover for the periods of prematurity. And the points about the scope of the permission to appeal, I think we did see when we looked at the Supreme Court's order. Oops, we didn't. Perhaps I should just show the court this, because I haven't marked these passages. I'm sorry. So I can do this in 2 stages and very quickly. The first is the order of the 8th of April 2019, which is still in the supplementary bundle, page 44. And just to give the court the chronology, there were appeals, and one set of appeals had been stayed for a very long time against this court's judgment in 2010 in FII that had been put on ice. Then, of course, this court gave, it was actually a third judgment in 2016. There had been an intervening trip to the Court of Appeal in 2014, as it happens, on the FIDS issue, but we don't need to say anything more about that. Mr. Justice Henderson talks about that in his summary judgment. And then there is then an application for permission to appeal against what we call FI Court of Appeal 2, so the 2016 Court of Appeal ruling. And the Supreme Court at this stage has dealt with this on the basis of written submissions, and it gives permission on some issues, and then it directs an oral hearing in respect of others, and that oral hearing takes place later. And by this time, of course, the Supreme Court has decided prudential. That was July 2018. So we're now in April 2019. And the court deals, point 1 is the appeal against the 2010 Court of Appeal ruling, which we don't need to concern ourselves with at the moment. And then it's point 2, Roman 2. So permission to appeal be granted in respect of 10 insofar as it relates to the SEMPRA issue. And then Roman 3, issue 10, save in respect of the Sempra issue, for which permission has already been granted. That's to be adjourned for oral hearing. So that's Roman 3. And then the oral hearing takes place, and the order given after the oral hearing starts at page 47. And the second recital, by what would be the second hole punch, tells us the hearing had been on the 27th of June 2019. The relevant part of the order is in paragraph 2, it's on page 48. And permission is refused on issue 10, save as insofar as permission has been granted in Roman 3 below. And then in Roman 3, the court reiterates the grant of permission that had already been given in the April order, granted insofar as it relates to the Sempra issue. There's no definition at this point as to what the Sempra issue is. I dare say you get some insight if we looked at the various written submissions that were made, but I will show the court the paragraphs in the Supreme Court's judgment that shows what was understood. Just for completeness, there is a list of issues, page 49. But issue 10 is simply set out as FIDs and summary judgment. And then 26A, which is what we saw in the court's eventual order, that was the question whether interest should be simple or compound, and that ties into the Sempra issue. Just pausing there, in answer to the court's questions last week, I think we did supply a copy of the list of issues that was before Mr. Justice Henderson in 2014. But what it does show, my lady, is that issue 10 was the broader question of whether all ACT payable on FIDs was unlawful. That's the aspect for which permission is refused. So there's a question of liability for summary judgment. That's dead after the Supreme Court's refusal of permission to appeal. What is live is the question of quantification, which is referred to as the Sempra issue. And then I think the place I need...
And specifically, if I understand it, the summary judgments.
Issue 10 is specifically in relation to the summary judgments. Well, BAT in the test case also had FID claims. So your ladyship is right that it is specifically in relation to the summary judgments. It also, however, affects BAT, who got a final judgment in 2014 following the what we call the quantification trial, although there were issues that went beyond quantification at that stage. I'm not sure if I'm just complicating things unnecessarily, but
you're saying that issue 10, as expressed, went beyond the summary judgments because BAT got a final one.
Yes.
Covered FIDs.
Yes, that's right. Yes. What I'm distinguishing is the question of liability. Was there unlawful tax charged under the FID regime, and was there a San Giorgio claim for its return? That's the point on which permission is.
So you've common ground on that.
Well, then, in which case I'll do this quickly. What went forward was how that entitlement should be computed. And that was the question of, is it Section 85, or is it, as we said, a situation where the revenue was held to what had been the earlier concession on compound interest, because they were ultimately, as we saw, allowed to withdraw that concession. Can I please show the court what in my submission is probably the best explanation of this? We did touch on this with my learned friend, although I don't think we looked at it in detail. It's paragraphs 49 and 51 in Supreme Court 3. So that's authorities, tab 12, and the passage starts at page 163. And the court there is recording by the letter E the limited grant of permission to appeal in respect of issue 10 insofar as it relates to the Sempra issue in issue 26A. That's what I just showed, Your Lordship. And then the court explains what that entailed. Permission was thus given to raise the question whether interest should be simple or compound, and then permission was given to withdraw the earlier concession in respect of semper interest. That was without prejudice to the various arguments that we ran out before the Supreme Court. Then they mention the summary judgments in paragraph 50. And I think we did touch on this passage. There's the common ground that it was compound interest. But then it was only simple interest for the period after utilisation or repayment. And then 51 is dealing with the scope of permission in relation to the summary judgments. And it's particularly the last sentence, which I don't think my friend focused on, and the court may have seen it when it was reading. So the revenue were not allowed to challenge the finding that all ACT charged on FIDS was unlawful, but were allowed to raise the question of what was the appropriate remedy for the time value of money during the period of prematurity in relation to unlawfully charged ACT, including ACT levied on FIDS. And it was, of course, an important part of the revenues case. And one sees this in paragraph 85, page 171, that how interest should be computed, 85 just by the letter H, that should be on a simple interest basis under section 85 of the 2019 Act. So you've got the revenue at this stage positively relying on the existence of the Section 85 remedy. Their position was that was the answer. And then when one reads through the various points, it's first of all the claimant saying, well, the revenue shouldn't be allowed to take this point. That's rejected. Those are the arguments on issue estoppel, abuse of process and the like. And then there are the points on how you construe Section 35 capital A. And the revenue says, well, it's not, so the Supreme Court says, it's not a mistake-based claim. So nothing's been sort of taken away from you. You look at the position as it stands now in terms of vindicating the EU law entitlement to interest, and there's nothing inadequate about the Section 85 remedy, so that's enough. But where this gets us to is a place where Evonik remains entitled to judgment on the FID component of its claim after the Supreme Court's order. What then still needs to be done is, well, how much is that judgment for? And as we saw, there isn't a provision in the Supreme Court's order requiring Evonik to repay the 6.4 million. We don't, of course, know what would have happened. There may well have been argument about it had the point been raised before the Supreme Court. What we do know is that by the time the point was raised, that was in front of the judge in June 2024. And by that time, it is clear that the revenue is going to have to make further payments for Evonik. And so in my submission...
Sorry, just before we go on, before we leave, unless you're sticking with this case, we were taken this morning to passages that say in terms, 118 and I think it was 234, that say in terms that the summary judgment should be set aside.
Yes, that's right. And that has to be approached, my lady, against the background of the scope of the grant of permission that's been given. So one has to look at this by reference to the orders that the Supreme Court has made, in particular that the question of liability to make restitution in a broad sense. I'm not getting into mistake of law and Woolwich, but the obligation to make restitution in a broad sense in respect of FIDS, there was no permission to appeal given in respect of that. So yes, the order and the judgment refer to the summary judgment being set aside. Paragraph 234 talks about recalled, and that no, friends, absolutely right. We assume that is Scots legal terminology that's analogous to setting aside. But the Supreme Court cannot be setting aside something to the extent that permission to appeal has not been given, because that simply isn't before the Supreme Court. There's no question before the Supreme Court as to the liability to make restitution in respect of FIDs. What is at stake is how should the restitution be computed. And that, in my submission, governs how one then needs to understand that use of the concept of setting aside in the ultimate order that's made in May 2024, as it happens, just a month before the judge is faced with these questions.
Well, I want to make slightly heavy weather of this. The determination of liability was determined summarily, but is only declaratory, isn't it? It doesn't. What then matters is the money judgment.
Well, that's true.
The money judgment has been set aside.
The requirement to pay the amount, we know it's not going to be the amount in paragraph 1 of the March order. That's right. What we do, however, know is that there is going to be an amount that is due. It's going to be whatever amount is produced by applying the Section 85 rates, because there's no debate about it.
It doesn't give rise to an immediate obligation to pay money, does it?
No, it doesn't. I'm not saying it does.
But why does it matter for present purposes?
Well, because what we're looking at is a circumstance where A, there is going to be money due to Evonik in respect of the FIDS claim, and also where by the time this question is ventilated, we know actually that there is going to be further money due to Evonik as well, which further money exceeds the 6.4 million that's been paid. That's what I get out of this issue. I don't want to get into a sort of semantic debate or to say does it matter? I'm so sorry.
Well, I'm still trying to understand your submissions, because effectively saying that it's varied, does that mean that Mr. Justice Henderson should be regarded as awarding interest under Section 85? He can't possibly have done.
Well, he couldn't have done in 2016 because Finance Act 2019 Section 85 hadn't been enacted at that point in time. I mean, that was one of the points the Supreme Court makes in Supreme Court 3, is you have to look at how you vindicate the EU law San Giorgio entitlement. You look at how you vindicate it at the time that question is before the court. Actually, there is an echo of that in what the judge has done here. The point I'm making is one that really goes to the justice of the position and what needs to happen to that 6.4 million in consequence of what the Supreme Court has done. Because the point I'm emphasising is that there needed to be a recomputation of the amount owed in response to the FID claim. And that's important when we get to the question of what entitlement the revenue has when it comes to restitution of that 6.4 million, and in particular in relation to interest. That's why, as I said, I don't want to take up too much time with the question of exactly what has this order done, because in a sense, a lot of time has passed until the order was made, and then we get...
Try and understand the drift of your submissions. As I understand it, the reason you're making this submission is, on your approach, the Supreme Court is saying recomputation is required.
Yes.
You say, by the time the High Court get round to that, we know all the facts.
Yes, that's right.
Therefore, the judge is entitled to
Yes.
do what he
And that's important for the course the judge then took.
But you're not saying that the order itself, which is set aside to that extent only, has effect other than to set aside the whole of the money order.
Yeah, that's right. That's right.
which I think is common ground.
Yes. Which I had mischaracterised you as saying when I was putting it to Mr. Wilmot Smith.
Well, at least I've clarified it. But what I'll do, if I may, is pass to my point 2, because that's the real battleground between us. Is what's the effect? What's the effect of this order, and in particular, is there an entitlement to interest on the £6.4 million? Because my submission is that there is no such entitlement My learned friend, as my Lord Justice Phillips rightly observed before the short adjournment, he has rowed back from the very stark way in which the point was put in writing, because there it was said that the entitlement arises automatically, and it was said to take place as of right. I still say that that submission is wrong. Learned friend was right to row back from it. It is no doubt the case that such an entitlement may arise in certain cases, but importantly, the entitlement doesn't arise as of right. It doesn't arise automatically. What matters is the justice of the case, and I'm going to address you on what the justice of the case involves here, because my submission is that the judge was absolutely right in the analysis that he undertook of the competing interests in his first and second judgments, or at the very least he was entitled to the evaluation that he took. Because the key point is that an entitlement to restitution, and this is whether it's of the principal sum, but more particularly for our purposes, whether it's of interest, that will be held to exist where, and only where, that right is required in order properly to unravel the consequences of the order in question being set aside. And what I'm saying is that there is no requirement, indeed no justification, for recognising such an entitlement in this case. What I wanted to do was go very briefly through Roger.
I'm sorry, Mr. Brennan, just so I
Yes.
understand the drift of this, this really, to state the obvious, is really all about interest. So let's
Yes.
say you were, Mr. Wilmot-Smith's submissions were accepted, that there was some form of entitlement arising from setting aside the content order to a repayment of 6.4 million.
Yeah.
Are you, this point in your submissions, can they be summarised as saying it wouldn't be just to award interest?
That's right,
Is
because
it as simple as
because
that?
I'm particularly focused on the interest. I have no difficulty, and I've never had any difficulty in saying that Mr. Wilmot-Smith's clients are entitled to credit for the 6.4 million.
Right.
There's
And that could be credited today or 2016.
Yes.
I mean, I know your case is put more on allocation to interest in 2016, but were this court, if let's say we were a first instance court, to say, right, you had to account for in principle repay the 6.4 million. You have no trouble. You have no problem with that.
That's exactly correct. You could do a slightly different exercise, which is simply to say, look at matters in, say, where the judge was in 2024, or even look at matters here, 2025, and say, okay, Evonik is entitled to, it's going to be a number that's bigger than 22.5 million by this time. I'm not quite sure in my head what the number is, so it's 30 million. You would also say, well, Evonik's got 6.4 million. You've got to take that into account in what else is due to Evonik.
Yeah,
that's fine. What's objectionable
that's
is
setting it off today.
Yes.
Which has no implications for the quantum of interest.
Yes, that's right. That's right. What in my submission is objectionable, as I'll be developing, is running interest on the 6.4 million from 2016. If we're focusing in more specifically, that is what is objectionable about the revenue's approach in this case. I hope that assists, my lady. So I was going to deal very briefly with those three cases. Roger, which was really the authority that my learned friend focused on, which is in the authorities at tab 14, starting at page 230. And I just want to emphasise a couple of passages in the Lord Chancellor's speech. So that starts at 238. And my friend took you to the passage that begins at the bottom of page 239. So the court's seen this. This was the point that it was in the power and became the duty of the court at Hong Kong to do everything and to make every order fairly and properly consequential upon the reversal of the original judgment. And as we saw, the top of page 240, the court in Hong Kong had thought that it could order restitution of the principal sum, but it thought it didn't have power to order interest. It's a point about jurisdiction. But then what is important, and I don't think Nefren emphasised this, so the question that's being considered in Roger, this is the end of this paragraph, it's whether the court at Hong Kong had or had not that power to order payment of interest. And then the next bit's important. And if so, whether in this case it was or was not proper to exercise that power. So there are two stages to this. Can it be done? And if it can be done, should it be done? And it's in that context, and I won't take up time with this because the court's looked at the passages further down the page, that you have the reference in the final paragraph on page 240 to the Lord Chancellor saying, well, if they can't have interest, it's the second sentence, it's obvious that if so, injury and very grave injury will be done to the petitioners. And that's what feeds the need for the money to be restored with interest in the circumstances of that case. So Roger is an example in my submission of the court responding to the justice of the case. It is not that the claimant was entitled to interest simply and without more because the previous court order had been set aside. He's entitled to interest on the facts because if he didn't get one, he would suffer, as the Lord Chancellor put it, injury and very grave injury. So that supports my submission that what one needs to examine is the justice of the case, what order is required.
And just in that context, we raised before about the other cases,
Yes.
Including other summary judgment cases.
Yes.
And I realise you're not here to argue the other cases.
No, I'm not appearing for the other claimants today.
They all are all part of the globe.
Yeah.
Is the position, for example, for Invensis still outstanding? Because you mentioned that with Invensis, the FID amount might exceed the overall amount due.
I think Milana Friend mentioned that, but I think,
Sorry,
but yes, and I think that's correct.
What would you suggest is the extrapolation, if any, from this, what you say should be the result in this case, to that sort of case as to what the revenue should receive?
So as your ladyship putting to me the sort of case where actually there is a balance at the end of the day owed back to the revenue.
You asked the judge below to ask to
yes,
specify
because I think we did try to do this both in relation to the GLO and in relation to interim payments, and the judge, and one can I suppose see why, said well it may be fact sensitive, so one has to be careful. There may be limited value in having a determination of a GLO issue. The court can see that in his judgment. We're living with that, and I can see it may make a difference on the facts. One can see that if the result is that money is owed back to the revenue, then the scales of justice may weigh differently. But it would depend on the circumstances of that particular case.
Well, indeed, but then what's driving my question as to whether the justice of the case is affected by the fact other cases might show that one approach or other is right or not, or to be preferred as a matter of principle. I'm expressing myself badly, but if you take the case of an Evonik equivalent that didn't get summary judgment in 2016,
Well, my lady,
they
then
would be in a different place.
then no question of repayment arises, because your ladyship is simply hypothesising a follower case. The claim is stayed. There's then a ruling in the test case, and then once the ruling's delivered, the follower at that stage says, "Please, can I have this money?" This issue simply doesn't arise.
But what's being said against you is that you're trying to circumvent that result.
Well, we're not, Malin, and the judge did look at this in his second judgment, because the judge was alert to the potential issue of overcompensation, and he found, and my submission is he's perfectly entitled on the facts to find that there is no overcompensation. It's right that there could be different fact patterns in different cases. It may also be the case that those different fact patterns lead to different answers. What that does not lead to, though, is a situation where it's appropriate to then drive the result in this case. What one has to do is look at the justice of the result in this case. And in my submission, what is a particularly weighty factor in this case is that it is Evonik, which we now know has always been out of the money. That's the factor that's particularly important. And it isn't, in my submission, relevant to say, well, what might have happened if summary judgment hadn't been sought? What might have happened if the Supreme Court hadn't overturned the summary judgment? That isn't relevant to this exercise. I hope that helps, Milady, in answer to the question on other cases. I was going to deal briefly with Nike Credit and then look at Delta Petroleum. Nike Credit is tab 8 of the authorities. And we're in the speech of Lord Nichols at electronic 56 at the bottom of the page, at letter H is where this begins. And one sees the factual circumstance. This was where some of the money fell to be repaid. So that's different to us. And question, is there jurisdiction to award interest on the money? Answer, top of the final paragraph, yes. No inherent power to order payment of interest, but this is directed at a different question, says Lord Nichols. And he emphasises between A and B at the top of page 57, what's happening is we're unravelling the practical consequences of orders made by the court below. And he says above the letter B that result could, in some cases, and I underline in some cases, be an idle exercise unless, put short, consequential orders can be made, and thereto achieve as nearly as reasonably practicable the restitution which the result requires. And that requires power to order repayment of money. It also requires that in suitable cases, and again I would underline in suitable cases, the House should have power to award interest on amounts ordered to be repaid, otherwise the unravelling would be partial only. And he goes on to explain between C and D that these are powers essentially implicit in the court's appellate functions. This is part of the inherent jurisdiction. So, of course, the court has power to order repayment and to award interest. No one doubts that the power exists. The judge didn't doubt that the power exists. I mean, he said in his first judgment that the Supreme Court could have made an order for repayment. But what matters in my submission is that this power is one that applies in some cases, and it's a requirement which applies in suitable cases. It's a case-specific power. Or putting it another way, it's the court responding to the demands of justice in the particular case. The paragraph of the judge's judgment I had in mind is paragraph 20 of the first judgment. That's where he notes that the Supreme Court no doubt could have ordered repayment, but that wasn't what was done. And then Delta Petroleum, just briefly, because it's a very similar point. Authorities tab 16, and then in Lord Legate's judgment, picking it up at paragraph 50, and I think we touched on this earlier, the rationale for this, just above the letter C, it's to give practical effect to the decision. So what we're dealing with is the requirements of justice in the particular circumstances of the case. And as it happens in Delta Petroleum, what one sees in paragraph 55 and following is the buyer actually trying to make an argument that it does have a defence to such an order, but that defence is rejected on the facts. That's paragraph 65. So if one looks at the position before the judge, what was needed in order to give full effect to FISC 3 was a recognition that 6.4 million was able to be credited against the amount that is due to Evonik. But there's no need in my submission to hypothesize a restitutionary claim for the 6.4 million, and there is certainly no need to hypothesize that that claim should carry interest.
In that case, usually meant is at what date do you give
When your lordship says in that case, you mean in this case?
In any case, if you're saying we don't hypothesize restitution, but we give credit, so there's no interest, but you give credit. So
Yes.
the key thing is at what date do you give the credit?
Well, in my submission, the straightforward way of doing this in this case was looking at what had happened as at 2016, because that was when payments had been made and when a judgment sum had been computed. And so the judge looks at that. That gives effect to the fact that the revenue has paid over some money. What he then says is, well, interest continues then to run on the amounts upon which it should be running. And that, because you can see that in the 2025 order. And then you draw up the judgment sum as at that date. That's in the...
As I understand it, you get to the same result if you say, I'm doing the setting off now,
Yes.
but I don't award any
You would.
interest to HMRC.
Yes.
So if we didn't think the judge's approach was right because he should have recognised that in principle the payment of the 6.4 million was the subject of a claim, entitlement to claim.
Yes.
You would still succeed, as I understand it, and this is the core of the submissions you've just been making, by saying that it would not be just or appropriate in this case, notionally to award any interest to HMRC on that.
Yes.
And then you get to exactly the same result as the judge got to, if I
That's correct.
financially.
You would get to financially the same outcome just by a different route. Yes. So it doesn't matter in my submission whether this exercise is done as at 2025, looking to deal with the 6.4 million in 2025, or whether you do it in 2024, looking to deal with the 6.4 million in 2016. You would get to the same outcome. Because we know, standing here now and standing, and where the judge was standing in June 2024, that the 2016 part payment, that was less than the total value of Evonik's successful claim. That's critical when it comes to working out what the requirements of justice are. It's Evonik, we now know that was owed money by the revenue throughout, and that's even after the payment of the 6.4 million in 2016. So that, if we just focus on the numbers that were generated for 2016, because the nature of this is depending on what point in time one looks, there are going to be different numbers. But by 2016, it's £22.5 million. All of that 22.5 million, that was all money that should be Evonik's money to use. Yes, Evonik receives a payment of 6.4 million in 2016, but there's no injustice in Evonik having had the use of 6.4 million since 2016. That's why I say that while undoubtedly there's jurisdiction to make consequential orders, there isn't any justification to award interest on a repayment. It's just not appropriate in the circumstances of this case.
Is another way of putting it to say it's not appropriate to take steps to reflect the fact that by receiving 6.4 million in 2016, Evonik might have done better economically than if it received its whole amount now and had not received 6.4 million in 2016, because as we all know, simple interest does not provide the same level of compensation as compound interest.
That is one.
A lot of the fight in the litigation.
That is one way of looking at it. Yes.
Well, that's where the economics of this
Correct.
dispute are all
Because I absolutely accept, and I still bear the scars of some of the arguments, but I absolutely accept that we are told that Section 35 capital A is simple interest only. That's the world we have to live in.
But we shouldn't, if you like, go out of our way to make you stick with that if in circumstances where you've actually had money earlier.
My lady, it's not even so much make you stick with that. It's the court shouldn't go out of its way to make the matter worse. That was the point I made to the judge, and it's the point I renew before this court, because the judge's treatment of the factual background to this that shows that the judge was clearly alert to the revenue's objection about overcompensation. You can see that when he explains the question that he had put to the parties in paragraph 32 of his first judgment, because we'd said in writing, well, this is unjust because you're cancelling some of our entitlement to interest on the 8.8 million. That's the economic effect of what's going on. And the judge records where he sent the email, which the court has seen at the back of the supplementary bundle, saying, is that really what's going on? And he raises this in paragraph 32 of his first judgment, and he sets out my answer in 33, saying, well, actually, that's only focusing on part of the picture, because actually the revenue has had the use of more money in the meantime. And then he returns to this. In the second judgment, particularly paragraph 6, where he finds that there's no excessive compounding, and he finds that there's no unprincipled windfall, top of page 46 in the full bundle. So we did go through this before the judge, but it is that point that your ladyship's putting to me that is lying in the background to this. We all know that when it comes to interest, it's only Section 35 capital A on the surplus ACT. We know it's only Section 85 on the, relevantly here, the FID claim. But the point is that the computation at this stage should not make the economic result for the claimants move even further away from a commercial outcome. So I absolutely accept I can't have compound interest. That fight was fought in the test case and lost. But where I do take my stand is that it would not be just to reduce the entitlement still further by what I've said in writing, and I'm perfectly happy to say it orally, is a sleight of hand in hypothesising an unnecessary claim for return of the money plus interest. I should perhaps just make two short points about the basis of the hypothetical claim that's being advanced by the revenue, because my friend, I think, puts it as a function of unjust enrichment, because we heard quite a few times this morning about the four-stage analysis, and oh well, there aren't any recognised defences. But if one looks, for example, at NICredit, the jurisdiction is part of the court's inherent jurisdiction. That's consistent with what Lord Leggett says in Delta Petroleum. This doesn't actually fit the conventional four-stage unjust enrichment analysis. That's a point I've made in writing. And I do say that inherent jurisdiction, for the reasons I've given, it's just not engaged in this case. It's not necessary in order to give full effect to SC3 to order the return of 6.4 million plus interest.
Yes, but I think you accept that crediting the 6.4 is part of the inherent jurisdiction.
And I have accepted
yes,
that.
That's as far as it needs to go.
Correct. That's correct. The second point is to say, even if one were to look at this through the prism of the sort of textbook unjust enrichment analysis, so enrichment at the expense of unjust factor defences, it's very hard to say that there would be a cause of action in unjust enrichment anyway, because we know, and this was actually, as it happens, an important aspect both of prudential and of FII SC3, that the unjust enrichment cause of action does not generate a claim for time value.
Well, isn't that pointing at the wrong thing? Because the unjust enrichment would be the
6.4 million.
Order,
yeah,
having been wrongly made, not the underlying basis.
I'm sorry, perhaps I started in the middle of your ladyship's question.
If it is that principle, it's I received money pursuant to an order that has now been set aside, so I didn't properly have an entitlement to that order. You certainly can apply an unjust enrichment analysis.
Well, for the 6.4 million, what
yes.
you can't do is apply that to the interest.
No, but to the 6.4.
We're focusing on the interest. Because my friend's got to go in two steps. He's got to make good his entitlement to his 6.4 million, but he's also got to persuade you that he's entitled to interest on the 6.4 million.
He should receive it.
Or
that he should receive it.
Yes, indeed. And in circumstances where there's no basis for him getting back the 6.4 million because his clients owe more, it's very hard to see why they ought to get interest on top of that. We're told, it's paragraph 107 in FISC3, the first sentence of it, that Prudential shows that claims to interest are not restitutionary in nature. So that's why my friend's got to go through two stages. He's got, for his unjust enrichment analysis, to get him anywhere, to say, I can have return of the 6.4 million, and then under section 35 cap A, please in your discretion give me interest on top of that.
So which paragraph was this with?
Of FISC3, it's 107. It's page 177 in the authorities.
Are we only we're only looking at part of an important part, the new part of the picture up, aren't we? Because the reason this works for you is because the credit you're prepared to give, 6.4 million, you want to give against interest,
Yep.
not against principal.
Yeah.
So you want to have the money since 2016, not to pay interest on it, but then have that 6.4 million credited only against interest on which you are not entitled to interest.
Well, and that's why, as I was developing in answer to my Lady Justice Falk, it's important to bear in mind that the simple interest recovery is explicitly not giving a full commercial return, and that this was the point that we went through before the judge. In that, it's right that Evonik has been paid 6.4 million. But what I'm saying is that it's wrong in principle for that receipt to make its overall position worse by being counted against amounts which otherwise bear interest. If you're looking at what is
it means is that you are gaining exactly the benefits from having had the money for the last 9 years, that the general law lets you have it.
I'm not sure I'd accept it. It's certainly not exactly the benefit,
No,
but we're getting perhaps. I'm not sure what I quite understand. Presumptively,
money on which one can assume you will have earned more than simple interest.
well, we don't know what happened to the 6.4 million. There's no evidence about that. What we do know is that we're in a regime where, under Section 35A, there is a simple approach of saying, look at what's owing, and you get interest upon that. But that's why I emphasise that it wouldn't be right to make Evonik's position worse than it already is. I don't think it's right to say that Evonik's looking for.
Given the thing decided against you that Section 35A and indeed Section 85 are adequate remedies for the purposes of EU law, what you're saying about don't make matters worse, it just assumes that there's a recognition by the court that those remedies are not adequate.
Oh, I'm not trying to say that. What I am saying is that we know that the Section 35A award is going to be less than what the true commercial position would have been. That's
Yes,
the.
but we know that, but that's not necessarily the test.
But the question then is, to what does the Section 35A award apply? That's really what we're needing to focus on at this stage.
The counter-argument is that it's been decided at the highest level that the appropriate rates of interest are Section 35A and 85.
That they are sufficient to remedy the injustice which constitutes your cause of action.
That's right, but what one then has to engage with is what are those rates being applied to? That's the next step that one has to deal with. It's what the judge has done in my submission rightly, is to look at what is Evonik's overall entitlement. So he's applied. He's applied Section 85 and Section 35 capital A, and then he's recognised, well, we have to give credit for the 6.4 million. What is the appropriate way to do that? And he's explained why it is that applying the 6.4 million against interest in 2016, that does not lead to undue overcompensation. So it's not a question of doing something that's inconsistent with the Section 35 capital A or Section 85 regime. There's no such inconsistency in my submission. What we have is a payment that was made. We know, as a matter of fact, that payment was not made to satisfy the surplus ACT claim. It wasn't. That claim continued to be contested and is subject to the point about the established value order of Mr. Justice Raja, which we mentioned.
Just for completeness, would someone mind sending that order?
Of course, my lady, I think what we probably need to send the court is your ladyship's order sitting in the High Court, which is the
So we'll have no
established value order on the FID claim. I think I mean, if you want to see them now, I think we do have copies,
well,
but they can be sent in later.
electronically. I don't want to take up your time.
I'm obliged, but
Can you also at some point answer the question about whether Evonik means just one company or more than one company?
yes, I mean I can do that orally if time permits, or we can put it in writing. In terms of what I think will be helpful for the court to see, there's your ladyship's established value order 2021, that's dealing with the FID claim. Mr. Justice Raja's established value order 2023, which is dealing with the surplus ACT claim. And then there are, it's either 4 or 5 paragraphs in the statement of agreed facts for the trial in front of Mr. Justice Richards, which deal with Evonik. Because what you will see is that when you add together the two established values, there's an acceptance by the revenue that if the Evonik claim is limited to tax paid within 6 years of date of issue, it's around 4.1 million would be due, and that's the amount of the two established value orders. So that's probably what the court needs to.
But as you've said, your key point, a point you're making at the moment is that you obviously accept that the 6.4 million was not paid to meet the surplus ACT claim, which at that time was still in dispute.
That's right.
Even though there were established value orders in lower amounts later.
Correct. I can try and deal very briefly orally with your ladyship's question about the claimants, if that'll help. So if your ladyship has the order, which is the order under appeal, so tab 4 of the core bundle. The paragraphs requiring money to be paid are paragraphs 1 and 2, bottom of page 34, top of page 35.
Sorry, tab 5.
It should be tab 4. Starting at page 33.
Sorry, that's in my tab 5.
So I'm sorry. It starts at page 33 of my bundle, and then paragraph 1 of the order, and then paragraph 2. These are monies being required to be paid to holdings. Looking at the most recent iteration of the claim form, there are only 3 claimants which remain on the most recent iteration of the claim form. My instructions are, although we didn't go into this in front of the judge, so if the court wants to see the documents, we would have to supply them. Most of the claimant entities assigned their claims on the 20th of September 2011. There's some discussion of this in the particulars of claim at paragraph 7, which is page 58 of the supplementary bundle. Completing the narrative on the FID ACT, there are 2 claimants which had paid FID ACT One of those was Evonik UK Holdings Ltd. The other was Laporte Organisation Limited. And we have checked, and again, this is on instructions rather than anything else, but the Laporte organisation assigned its claim to Evonik UK Holdings Limited, 20th of May 2014.
Well, that's reflected without the date in paragraph 1A of the order.
Correct.
And I assume Evonik Degussa is
Correct.
Evonik UK Holdings.
Yes, that's right.
Thank you.
There were,
But the ACT surplus holdings, are they all Evonik UK?
they are all
holdings?
Evonik UK Holdings, I understand. Yes. So
So we can treat Evonik as a single entity
for these purposes, I
the whole
believe so.
22.5
I believe so.
is Evonik.
Yes, I mean, some of that you can trace back to assignments, perhaps, but many of them were made a very long time ago, and there's never been any contest about those. So,
Because it's unclear, because Evonik is shown, including on the appellant's notice, as being more than one.
yes,
And that's why in the order that's being appealed, the summary judgment in paragraph 1, page 34, is all in favour of Evonik UK Holdings.
yes, that's correct. So I hope that helps on.
Page 34.
Have I got the wrong one? I think I'm not right.
This would be
Tab 4.
I do have to. What's it called? What was the version? Apologise.
My Lord, I'm sorry, I think I'd slightly lost my Lord Justice Popplewell's observation. I think we were looking at the order under appeal, which is the 2025 order, which I've got on page 34 of the core bundle.
Yes, I wasn't quite sure that my lady had that.
No, I didn't,
order.
but it's still
And paragraph 1, those are
okay.
all sums
Okay.
awarded in favour of Evonik UK Holdings Limited. That's just the point
Yeah.
I was
Yeah.
making. And you say that reflects the fact that
Yes.
all the claims, FID and ACT surplus,
Yes, they either are holdings own claims
are in
or
favour of a single entity.
Yes. Either because it was their payments of tax or because by then they had been assigned to it.
Okay, I think I was looking at Mr. Justice Henderson's order, but actually it's also relevant because the 6.4 that was repaid went entirely to one entity.
Correct, because
So
because
that's also
Because there was
relevant.
already an assignment.
yes,
Yeah.
because
Yes. So I
Yeah.
was behind, but not with that.
my lady's quite right. One can and probably should look at both.
Indeed.
And I suppose just finishing the thought.
So it's
in the-
supplementary bundle 5.
Yes, that's right.
Which is where I was.
It's confusing because it's page 34 for both of them. But
Yeah.
if we're in the supplementary bundle, that is the summary judgment order. The summary judgment is in two parts because part of it is is the 7.6 million to holdings itself, and then the 3.8 million is to holdings, but as assignee of Laporte. And that was the point I made a minute ago about Laporte having done the assignment.
Thank you. I think
I'm sorry, I took
question's been answered.
I'm sorry, I took longer over that than I should have done, but I hope that helps.
I ask, perhaps coming
Of course,
rather slowly to the crux of it. If notionally it takes the 6.4 million as having been paid in 2016 in discharge of interest, then notionally you would have the 6.4 million for all this period, just as you in fact have had it.
so just as
You if it had been paid to you in 2016
Yes.
in discharge of interest,
yes,
then you'd have had the money
Yes.
for the whole period,
yes,
and it would not have resulted in any greater diminution of your claim because it was against interest.
Yeah.
But if it had been allocated against the capital ACT surplus claim, then that would have reduced your capital claim, and you would reduce your claim by the amount of interest.
yes, that's right.
So all of our argument about restitution whether or not it has interest or not,
Yes.
all comes back at the end of the day to one simple question. Does one notionally allocate the 6.4 million against interest or capital?
That probably is fair, my lord. Yes, subject.
That is the only, that at the end of the day is the only real question that was before the judge.
And you can see the judge grappling with that both in his first judgment and his second judgment, which and ultimately it's a question of the evaluation of the justice of the case. And it is important in that context that if you look at the 6.4 million, that is money that should have been Evonik's money. And that's why I emphasise that it would be
Yes, but should it have been Evonik's discharge of Evonik's money because it discharged capital, or should it have discharged interest? And that seems to me to be ultimately the one and possibly only question.
Well, your lordship may well be right that ultimately that's at the nub of this.
Well, it's the economic issue, and it also seems to me that probably, however one goes round the houses on all these legal issues, it's the legal question. Where does one allocate? There was a payment made to your clients in 2016 that was paid on an incorrect basis, as it turned out.
Yeah.
And so one has to allocate that payment against monies now held due to you, but which have been due throughout that period, and were due, although not determined to be due as of 2016. That seems to me, at least on the face of it, brings us into the question of what is the exercise that we're engaged, or the judge is engaged in, and to what extent the principles of allocation of payments comes into it.
Yeah.
And I know you say, well, when you look at allocation, you allocate first and foremost to interest.
Yes.
But it seems to me that one also has to grapple that allocation, prima facie, the first party entitled to allocate to the payable.
Well,
And if they don't allocate, then the payee can allocate.
well, and if you look at if you go back to what actually happened, it is a payment made under the order. But of course, the order is about the FID claim. That is a time value amount. We know that order has been recalled and there has to be the recomputation. There is no allocation at the time by the revenue. The revenue doesn't say we're paying this on the basis that it goes against the capital.
Well, it could once the order was set aside.
But it didn't.
Exactly. Did you allocate?
Well, we're doing it. If we haven't done it so far, we've certainly done it in the computations where when we apply for judgment, we say we're computing this on the basis that it's allocated to interest. We don't have the.
Are they not making an allocation at exactly the same time to contrary effect? I mean, you say they didn't allocate. That may be right at the moment at which the order is set aside. But if the allocation you're relying on is simply in the computation of your claim before the judge, was there not an allocation the other way at the same time by the revenue?
Well, it wouldn't be at the same time, Lord, on any view, because the application for judgment goes in first.
I say none of this was debated.
Well, I also, actually, I understood the judge to say that those principles of contractual
He didn't find particularly
allocation
helpful.
were not of assistance, but he found more help from the PAR's banking line of cases.
Yeah, that's right.
Which, my understanding of which, I'll take a different approach to the sort of contractual choice. You know, payer can allocate and then pay in favour of a so-called rule of thumb of interest.
Yeah.
I thought that's how the judge approached it.
Well, yeah, I think that's fair. Yes, because before him there was no one came along and said we have allocated, and I think I'm only in answer to your lordship's question saying, well, if we get that far, then you'll find one in the application. I'm not relying on that. Where the judge did get some help was on the point of principle, which essentially was one of fairness between the parties. So that was looking at the fairly antique cases, but none the worse for that, particularly Pars banking. I mean, if it would help, I'm very happy to show you briefly the passages that were in front of the judge. I think what I'm now doing is I have actually now segued onto ground two without sort of really noting the difference. But I think I am.
Before we go there,
yeah.
is there anything else?
The only point I think I needed to make was point 3 on no claim, that the judge was right to observe that there was no actual claim or counterclaim in favour of the revenue to be enforced. I simply note that emphasises that this can't be an automatic entitlement. The very fact that one needs to take steps in order to get an issue of this nature in front of the court it illustrates that more is required, and the court has my submissions on what it is that's more that's required. So in terms of the materials that were before the judge, if we're in the authorities, this went, I think, in 2 stages. Because we showed the judge an extract from Chitty, and this was paragraph 25066, which is authorities page 338. That's what the judge is referring to in paragraph 30 of his first judgment, which is core bundle page 41. So where there's no appropriation by either debtor or creditor in the case of a debt-bearing interest, the law will, unless contrary intention appears, apply the payment to discharge any interest due before applying it to the earliest items of principal. And the footnote, if one reads past the list of cases at the bottom of 338, that explains footnote 337, the presumption is based on what's normally the commercially sensible course the creditor would take, but it will be displaced if unusually the circumstances indicate otherwise.
It's the commercially sensible course as a rule of thumb, is it? Because you can't get interest on interest.
Yes, no, that's correct.
That's
the nub of it.
That's the nub of it.
And that also.
And we have to apply that in the circumstances of this case, where your claim is one for which the remedy is regarded as sufficient if you don't get interest on interest.
One has to ask what sums are in play that are eligible, if one likes, to receive interest. That's why there's the question of allocation. I'll do this briefly. Dispensing with very old cases, I'll just show the court the passage in Re Morley and then the point in Parr. So Re Morley is in the authorities, tab 7. Starting at page 39. And Mr. Justice Simons, he sets out the 3 possibilities at page 43 at the start of his judgments. This is dealing with legacies, and there's been delay in paying the legacies. So is it first principal and then interest, interest then principal, or is it done ratably on account of both? And you can see the problem arises, page 43. That's the explanation of the facts, because the testator had died and there'd been this delay in paying out the legacy. And then top of page 44, that's the question reiterated. And then the rule is set out 10 lines down. It's a sentence starting, I take it. I take it the rule is established beyond question by authority. It's where a payment is made on account of principal interest of a legacy. It's to be ascribed first to interest and next to principal. And then as we see towards the bottom of that paragraph, page 44, that's to be applied unless there's something in the will or something that's happened in the administration of the estate which precludes me from doing so, and held on the facts. Bottom of page 44, and then final paragraph on page 46, there's nothing preventing it. So that was the position there. And one gets a little bit more on the rationale for all of this, although the rule didn't apply on the facts, in Parr's Banking Company, which we touched on in opening. And it's Lord Justice Rigby's judgment, the final paragraph on page 37, where his lordship refers to the old rule that no doubt applies to many cases, that where both principal and interest are due, the sums paid on account must be applied first to interest. That rule, where it's applicable, is only common justice. And applying to principal, it would deprive the creditor of the benefit to which he's entitled under his contract. It would be most unreasonable as against him. The rule didn't apply on the facts because it was the usual practice for the debit balance to be carried over as principal, so that didn't help creditors in that particular case. But standing back from all of this, I have no difficulty, my lord, in acknowledging that the fight has been fought and lost on is compound interest available. As I said earlier, we know under section 35 capital A, it's simple interest. It's the same for section 35. But one does have to take into account here what is a windfall that would benefit the revenue. And this is what the judge remarked upon in paragraph 33 of his first judgment. Because on any view, there is a significant sum from which the revenue are benefiting from interest-free. We make it 7.4 million of interest-free cash.
Understand that when you say benefit interest-free. You mean if the revenues case is
even on our case, even on our case, my lady. All right. The reason for that, if one has the 22.5 million that the judge is working from, the revenue pays 6.4 million. The revenue is liable to interest on 8.8 million. The balance, which is roughly 7.4 million, that's what I say is the amount that on any view the revenue's enjoying, and there's no interest applicable to that. It's really just arithmetic.
I've lost you.
Oh, sorry.
Okay, I've got your table out at paragraph 22 of your skeleton, which I
Yep.
find helpful.
What's the balance? The interest-free.
But when you say it's interest-free, that's a consequence of simple interest, isn't it? This is what I don't understand.
What do you mean it was due since 2016?
Yes.
No interest has run on it since then.
That's right. That's all I'm saying.
That's a function of some simple interest.
But my lady, my point is that the fact that we live in a regime where it is generally simple interest, that does not drive the question of allocation.
And sorry,
That would be
just to understand the maths,
let me get my skeleton.
22.5.
The rounding causes complications,
Okay.
but the
Can I get
broadly it's 22.5. Hypothesize that the revenue has paid 6.6. I'm so sorry, 6.4. It's complicated enough without putting in other numbers. And then there is 8.8, which is going to generate interest on our case. That leaves at 7.3 million. My rounding hasn't quite worked.
So what have you done? Just deducted all of those amounts? 22.5?
22.5 minus 6.4 minus 8.8, yes. I don't want to over-egg the point. That point is just arithmetic, but what it is saying is that there is a sum of money that should have been paid to Evonik by 2016, and upon which Evonik is not going to get interest on any
Well,
view.
you say should, but if the summary judgment hadn't been made, you would not be able to argue that, to use your numbers, that 7.4 should carry interest, because you're only entitled to simple interest to judgment, which in the absence of summary judgment would have been in 2024.
Yeah, and had that happened, which is not what happened, Evonik would have been entitled to interest on the 8.8 million, and it would have had Section 85 interest on the FID claim to that day.
Yes. But it would be possible to interrogate those numbers and say, among other things, the revenues enjoyed 7.4 million, in fact a larger number interest free. On those figures, 7.4 plus 6.4.
I'm not quite sure I followed the question.
I don't think I can do more than repeat, but I think you're making a point that's really a criticism of simple interest.
Well, what I'm trying to say is that we're dealing with the question of allocation, and it is right that because Sempra was reversed, the Supreme Court has laid down an approach which gives rise to restitution at lower than what would be a commercial remedy, and there's no dispute about that. That's the law. What should not, though, be happening in my submission is a, if one puts it this way, cancellation of the right to interest to the tune of 6.4 million. It's not right. This is looking at the question of allocation. To see this 6.4 million as being allocated to the surplus ACT claim, that doesn't fit the facts. That's not why it was paid. It didn't discharge the claim in 2016. The revenue continued to contest the surplus ACT claim. They ran their limitation defence. Open brackets, yes, there was the established value order in 2023, but that doesn't particularly matter for my purposes. That's why I'm saying that it's not right to endorse an approach which, we're in a simple interest world. Evonik is already getting less than a commercial return. One should not be looking for an allocation which reduces the amount of interest still further. I don't accept that that involves me in making some sort of root and branch criticism of simple interest. I'm living in and adapting myself to the world where simple interest is what applies. That's why the judge, this is particularly in his second judgment, he does address, and this is his paragraph 6, that there isn't any inappropriate overcompensation. So there's no windfall to Evonik just because the revenue paid part of the sum that was due to it in 2016.
If they had voluntarily paid 1.4 million in 2016 in discharge of interest, would there be no problem?
Well, that's right. Yeah.
Because it was due to you.
That's right.
And that's the case, isn't it? And that's what the judge said. There's nothing wrong in saying that we will treat this 6.4 million that was paid in 2016 as been in payment of the sum that was in fact due, but was only just being sustained as due.
I mean, hazard a case where the revenue says we're going to repay you, but only on the basis that this goes against the principle. Credit is entitled to say, I don't want the money on that basis. Whether or not that's a good idea is a different question.
Unfortunate reality is that none of the above happened.
No, I recognise that, but that's why, in my respectful submission, the exercise the judge did was both sensible and correct. He put himself in the position he was at in 2024, knowing what we know now, and he looked for what the just outcome was.
Can I ask a different question?
Of course.
Let's say we were against you on, if you like, the principle of a restitutionary right. As you've said, you don't mind that, it's the interest that you're concerned
Yes.
about. One of the questions that was asked, that was, I think, partly answered, but we need your answer on,
Yes.
is the interest rate
So
that would apply under Section 35A, were that Crown 1 to be upheld in some now, I know you're saying nil, because that's what you've been saying all afternoon, but can we at least understand whether there's any fallback position, because some of the papers lead one to think that it's common ground that the rate is 2% over base, in whichever direction.
because I think in the skeleton, and I apologise for that, I think the point really, it's a forensic point being made that if it's interest at this rate, then the rates are asymmetric, was the point we were trying to make, because part of the Evonik claim is computed at the 0.5% rate, which is
can we
the
put
FIG
to
claim.
one
But
side the FIG claim and just look at Section 35A?
yeah, so your ladyship has the point. My starting point is nil. I'm not aware, we've sort of cast our minds back through things that have happened in the GLOs, of a Section 35 capital A rate being applied to the revenue. It's not obvious why government should have the same rate as an ordinary private party, bearing in mind that the base plus 1 and now base plus 2 rates, which are usually applied, say, in the commercial court, they're supposed to reflect conventional rates of borrowing. It's not obvious that government would be borrowing at those rates. As to what the rate should be, we don't have any evidence, so that creates a difficulty. I suppose that's why I emphasise, looking at the justice of the case, why actually there's no reason for any interest to be applied at all. So, there have been instances in the GLO. So, for example, in 2014, there was a lot of evidence about government cost of borrowing, and there were findings made.
That was all probably in relation to change of position.
It was in relation to the applicable interest rates in calculating the enrichment, but we didn't go into any of that before the judge on this application.
We should assume there is no consent. I just wanted to understand whether there was some sort of cast in stone agreed rate that works both ways.
No.
Because some of the papers appear to indicate
no. No, I think is the answer to that question.
Although both the respective claims have been formulated on the basis of the same rate.
I'm so sorry. I think my hearing is starting to.
The rival positions
Yes.
on what should be awarded have proceeded on the basis that the same Section 35A rate should be applied in respect of whatever it properly applies to.
I think that's probably fair, yes. I'm not sure that Land and Friends clients have put forward sort of detailed numbers. The revenues argued their case more by reference to concepts rather than to figures, but I think the assumption is as your lordship sets out. can I please just deal with some of the points in relation to allocation, and then I should say a word about the respondents' notice point before I conclude. So I've looked at the rationale. I think I've made the point about the justice of the case overall and how that ties into the rationale of what the judge was doing. There were a couple of more specific complaints, and in writing, I think it was mainly put by my learned friend as a criticism of the rationality of treating the 6.4 million as discharging a portion of the claim to unutilised ACT. And there was a sort of related point saying, well, there was no liquidated claim to interest in 2016. That was then slightly repackaged this morning. There were my learned friend's four reasons, which the court will remember. There was the revenue has this entitlement, I think was reason one. There are legal fictions. There were 3 identified, I think. It was said to be arbitrary, and then there were some points on fairness as well. So I was just going to address those matters. Really, the criticisms, both in writing and orally, in my submission, they misunderstand that the exercise that the judge needed to undertake. Because what one can't lose sight of is what was being done in 2024 was computing how much was due to Evonik. And looking at what the position actually was on the ground in 2016, so for example, had FA 2019 been enacted, is not actually a helpful exercise in that context. It, if anything, makes the same error that the Supreme Court identified in the claimant's submissions in criticising the Section 85 remedy in FISC 3, when they said you have to look at matters when it comes to the court seeking to vindicate the claimant's EU law rights. It's no good looking at what might have happened previously. So it doesn't matter in my submission that in 2016 we didn't have FA 2019. It doesn't matter that in 2016 Evonik's claim was still being contested and there were aspects of the claim that remained to be quantified. Because what we do know, standing in 2024 as the judge was, or standing in 2025 now, is if we look back to 2016, by that point in time, Evonik had overpaid 8.8 million of the ACT, and it should also have had, by that time, interest on the surplus ACT. It should also have had an award of interest in respect of the FIT. So it doesn't matter in my submission that those entitlements hadn't been established in 2016 itself. That's not the question. We can't lose sight of the fact that while it is no doubt the case that the Section 35 Capital A award, like the Section 85 award, is made at the end of the proceedings, that's the point the Supreme Court made in FISC 3. I think it was para 114, which we looked at in opening. As a matter of EU law, Evonik absolutely does have an entitlement to interest. I don't understand there to be any dispute about that, but perhaps I should just show the court the passages that make that good. It's prudential, paragraph 78, and there's also, that's applying a passage in Littlewoods. It's prudential in the authorities bundle. The judgment starts at page 90, but the passage I need is on 120. It's behind divider 10. And before I show the court 78, I should just explain what the category A claims were, because they're identified on page 106, paragraph 34, little a. So when the court is talking about a category A claim, it's unlawfully levied ACT, subsequently set off against lawfully levied MCT. That's what's referred to as the period of prematurity, or the Sempre period. And the problem which the Supreme Court identifies, having given its explanation that there isn't a restitutionary claim for time value, rather the entitlement to interest arises as a consequence of the existence of the debt. 78 says, read literally, no interest could have been awarded on the category A claims under section 35 capital A. And the reason for that is that 35A doesn't apply where the defendant has repaid the debt or set it off before the creditor has commenced proceedings for its recovery. Because you'll no doubt remember it, 35A talks about in proceedings for the recovery of any debt. So if the debt's gone before the proceedings, you're not within 35 cap A. However, an award of interest is nevertheless required in such circumstances by EU law if an effective restitutionary remedy is to be available under English law in respect of San Giorgio claims. That was the point decided in Metal-Gesellschaft. That's also the Hearst case. It's the same case. And when I said Hearst, Hearst was the other party. And the court didn't need to decide how the award of interest should be made available. The reason for that was because the revenue had conceded that the category A claims in Prudential were to receive compound interest. But what the court is recognising in 78 is that as a matter of EU law, there was that entitlement to interest. There are lots of examples in the EU cases of that entitlement being recognised. The only one in the bundle is in Littlewoods, which is in tab 15, and the paragraphs are 25, page 265. The court explains the San Giorgio principle. It's reimbursement not only of the tax unduly levied, but also of the amounts paid to that state or retained by it, which relate directly to that tax, and that also includes losses constituted by the unavailability of sums of money as a result of a tax being levied prematurely. And then 26, it follows that the obligation the translation isn't very good in 26, but it's the obligation to repay with interest amounts of tax levied in breach of EU law. 27, of course, how you do that's a matter for the national law, but 29, it can't lead to the taxpayer being deprived of an adequate indemnity.
It's my fault, but does that tell one anything about the rate at which
No, it doesn't.
such interest should be awarded?
No,
And if
not directly in the law.
if for FID claims it's regarded as sufficient recompense for the time value of money to award interest at the section 85 rate, is there anything that says that that wouldn't be an adequate rate under section 35A?
No, and the Supreme Court has held in FI Supreme Court 3 that the section 85 rate is an adequate indemnity.
And that would be so. Not, I mean, that was so for FID claims.
Yes.
But why would that not also be the case for other claims where European law said you must have a sufficient remedy? Where one's looking at the time value of money. So under section 35A.
Oh, so
why shouldn't you apply the section 85 rate?
Because it's been decided that for section 35 capital A, the rate is higher. And I'll just show Your Lordship the Supreme Court's order on this. If you just give me one second, I'll need to find the reference.
I think strictly this was effectively common ground.
It was, yes, that's right. But I just need to, I think I can just show you.
This SC3.
This is the order following SC3, which I was failing to find. It's supplementary bundle, page 51. So this has been decided This is looking at it from the point of view of the taxpayer. So the Supreme Court's ruling, it's paragraph 1, Roman 2. And this is looking at, is interest simple or compound upon surplus unlawful ACT, which is utilised against unlawful D5 tax,
I see. At
cash
that
basis.
particular risk. Okay,
And
thank you.
So that's been decided.
Our surplus ACT, our 8.8 million,
Yes, milady.
is covered by that provision in this.
That's certainly my position, milady.
Thank
Yes.
you.
Thank you.
I hope that assists me.
So that answers my question. Thank you.
So many of these points on allocation, saying it doesn't fit the facts, or that wasn't the position back in 2016. Really, the flaw with those submissions on the revenues part is that they overlook that the judge's task was to carry out that calculation, and it's a calculation being done in 2024 of the appropriate amount of restitution. And you can see, for example, in paragraph 4 of the judge's second judgment, the judge is well aware that interest hadn't crystallised into a liquidated sum in 2016. So he understood that, but he was quite right in my submission to hold that given the nature of the exercise with which he was concerned, conceptually it was entirely possible for some of the payment of 6.4 million to be treated as reducing the interest that has accrued. Of course, this is an exercise that's being done after the event. We've used the word notional quite a lot today. But there's no difficulty in working out, sitting in 2024, that by 2016 it's this amount of principal and this amount of interest, and the fair approach is to do as the judge did. So I think I've made the points I needed to make on ground 2. I don't think I really need to say very much more by way of drawing the threads together. I mean, the point I've emphasised several times already is that by the time this question comes to be ventilated, it's established, indeed it's not disputed, that the revenue owes Evonik far more than the 6.4 million that had been paid back in 2016. And that conditions, in my submission, the analysis that it's not appropriate for the 6.4 million to carry interest in the revenue's favour, nor is it appropriate to allocate the 6.4 million to principal, thereby cancelling what would otherwise be the entitlement to interest that Evonik would have.
I think you make the point, don't you? I'm not sure how much you've addressed it. You also say, in relation to ground 1, I suppose, there was no claim for restitution here.
Yes. Yes, I said that in writing. I sort of passed over it a little bit orally, other than to say orally that it emphasised that the entitlement couldn't be as of right as the revenue had said. But I do also say I'm not in any way departing from what I said in writing. I adopted the submissions I made at the start. The judge was perfectly entitled to say, well, I'm asked to look at this hypothetical entitlement to restitution, but this is by reference to a claim that's never been made. That's a further obstacle. He was perfectly entitled to take that into account. And it really doesn't make sense. No one tries to meet that by saying, well, if I hadn't done the right things, I should have been given the opportunity to go and issue a claim or make an application. That can't be right either.
Well, at the point, the exercise the judge was engaged in was assessing how much was payable to your clients.
Yes.
And part of the one factor in there. HMRC had paid you 6.4 million back in 2016, for which at the moment was unallocated at least 4 million.
Yes.
But to then say, well, in fact, I have to regard there as being a restitutionary claim for that sum,
Yes.
carrying interest. You say that a factor in deciding that that's not the right approach is that there's never actually been a claim.
That's
or
right.
restitution.
That's right.
Notwithstanding that it was some time since the Supreme Court decided to set aside the orders.
Yes, that's right. I'm not sure whether there's a great deal I can add to that. It's clearly not a central point in the case, but it is a point, at least a background, that the judge was entitled to have regard to.
Well, it wasn't very long, was it? It was set aside in May.
It depends whether one looks at.
The hearing before the judge was in June.
It depends whether one looks at the order or the judgment, because the judgment had been given in, if I remember rightly, July 21. So there was quite a long delay between the judgment and the order. And that, a friend may well say, well, there was nothing we can do until the order happened. But even when the order happened, the claim wasn't made at that stage either. As I say, I don't want to make a meal out of the point, but I'm simply saying that is what happened, and it's a point the judge was perfectly entitled to have regard to say, I have no application before me, I have no claim before me. I think I've dealt with the questions that the court already put, perhaps save the last one, which was the 8.8 million, although perhaps I've at least touched on it, because the fourth question was whether the 8.8 million of surplus ACT was that in dispute in March 2016. Yes, it was.
Yes, I think that's
I think we've done that. So I wasn't going to say anything more about the questions unless I could help any further with those. I think that only leaves me with my topic 5, which is the respondent's notice point and the alternative case, which I was simply going to outline quite briefly. This proceeds on the footing that the court reverses the judge's approach, so that wasn't the right approach. And one is then asking, well, there needs to be some different methodology to the one which the judge applied. And on that footing, my submission would be, so the court has my points, we shouldn't get to this point, but if we do, that the preferable course is not the approach that the revenue urges. Rather, we say the more principled approach, and this is in paragraphs 83 to 90 in the skeleton, is first to apply the part payment to meet the FID claim. So that's the component of the claim towards which, as a matter of fact, the payment was made. That, of course, doesn't deal with all of the 6.4 million. So question, what do you do with the balance? Answer, you prorate it between principal and interest in relation to the remaining aspects of the claim.
When you're applying it first to the FID claim,
Yes.
is it right to apply it to a full 2.324 million when the 6.4 is reduced by withholding tax, but the 2.324 isn't? Or should we actually be applying it to 2.324 net of withholding tax?
No.
Take withholding tax out of it.
One just takes the withholding tax out. One doesn't need, what Evonik has received is a cash payment. It so happens in the events that have happened, and I think this is the result of a combination of Prudential and FII Supreme Court 3, so that the withholding tax applies to so-called restitution interest. So that's a defined term in Part 8C of the Corporation Tax Act 2010. Ultimately, the revenue is disposed to accept, as we understand it, that interest, simple interest under Section 35 capital A and interest under Section 85 does not attract that tax charge. So it is not restitution interest as defined. And that's because it is not interest otherwise than at a statutory rate as set out in the provisions. I'm sorry, we don't have the provisions in the bundle, and I haven't brought them along with me either. But where we start on with the withholding tax is that because of the limitations on the restitution that follow from the Supreme Court's judgments in Prudential and in FISC3, the withholding tax can't apply. So in those circumstances, it wouldn't be right in my submission to reduce the amount of the FID claim by the withholding tax.
Because
There's
the
no,
withholding tax relates to restitutionary interest.
yeah, and that's not what we're dealing with.
A much smaller point is that if one were to take the approach in the respondent's notice, presumably the offset is against the 2.3, whatever it is, as further increased by interest since 2016, because that's a 2016 figure, isn't it?
It is. Well, I mean, we've done the exercise in 2016, so I suppose there is a separate question as to at what point in time are you doing this. I mean, being consistent, the exercise the judge did was a 2016 exercise, and so we've gone along with that for these purposes. But if the court were to say actually you should be doing this at a later point in time, then I see your ladyship's point. Can I just go back half a step though? Why are we suggesting this at all? The reason we're suggesting this at all is because when you look, and there have been a very great many computational issues in this GNO, some of which have had to be argued several times, perhaps more times than one might have wished. But as we explain in the skeleton, the recurring theme when the answers have been given to those computational issues by the court is that where possible one looks for an analysis of principle. So one tries to find what's the point of principle that drives this. And if you can't do that, in default of an answer of principle, the fair solution is to prorate. That's generally been what has been done. And we give the particular, and it probably isn't very useful at 5 to 4 to start to embark on it, but we have in mind, this is paragraph 87 in the skeleton, the Supreme Court's approach to the question of utilisation. So this was going all the way back to the point I was making, I think just before the short adjournment. You had this undifferentiated fund of ACT. You have to work out how much is lawful, how much is unlawful. You have to work out how much of that has been utilised against lawful MCT, unlawful MCT. You have to deal with things like there has been a surrender to a subsidiary company. How do you do all of that? Where we got to in Prudential was you found an approach of principle, which was that you identified the unlawful payments to the extent you could, and you allocated unlawful to unlawful, lawful to lawful. And then with the balance, then there was prorating. So that's just an illustration of a sort of wider point. Can we find an approach of principle? It doesn't directly answer the question here. It's simply an illustration of where you can. If you can find an approach of principle, you should adopt that. Here we say there is an approach of principle, and it's to focus on what actually was the payment of the 6.4 million for. It was, as a matter of fact, a payment of the FID claim. It was certainly, that's what the order says, and the amount was calculated at the amount that was due for the FID claim on the revenues case, at least as it stood in March 2016, because of course it was accepted by the revenue that was compound interest for the period of prematurity. It was simple interest only. That was the claimants accepting the revenues then applicable approach for the post-SEMPRA period. So that was in fact being paid, to satisfy the FID claim. That was why the money was being paid over. We know, of course, that that order is later set aside to the extent of the SEMPRA point. We also know that that FID component of the claim, it is a component made up of time value amounts. Because under the Section 85 remedy, there are two aspects. You work out the notional principal amount, which is the period of time between payment and then repayment, and then you also then apply interest on that notional principal amount that's just been calculated.
And just to be clear, that 2.3 million must reflect both of those elements.
Yes.
In Section 85.
Yes. That, of course, does not deal with all of the 6.4 million, because the 6.4 million is worth more than the amount of the FID claim that was due on the Section 85 basis. So what then do we do with the balance remaining? The balance remaining, we say, should be prorated between principal and interest, because at that point in time, if I'm wrong on the primary case I've advanced supporting the judge, there isn't a particular approach of principle that directs the answer. And that's why we at that point default, if you like, to pro rata, because there isn't a more principled approach to apply. And then I've set out, this is in 90 sub 3, that's just the arithmetic of how you would actually do the pro rating. So you've dealt with the amount of the FID claim. That then leaves a balance, and then you prorate between principal and interest. So that's the explanation for the respondent's notice point. It's ultimately quite a short point. Would you like to just give me one moment? For the prorating. May I just ask a question, which is whether the court would like any more help on the numbers, either on the 22.5 million or indeed on the prorating. I hope I've made my position clear on how the 22.5.
Notice, I think that's clear from them.
I'm obliged. Those are my submissions.
Mr. Wallace.
Grateful. Excuse me, I'm grateful. I have two short points and one slightly longer point. The first short point is on the construction of the order. I, like Lord Justice Popplewell, had not read my learned friend as conceding that the paragraph was set aside. My learned friend now does accept that. In my submission, that is a quite significant concession relative to the point on variation, because it does mean that, as it were, through the first limb of the two propositions that I set out for the court this morning, except I have to get the second one. The reason it is set aside, a reason, is because it was quantified and codified by reference to causes of action that didn't exist. I've made those points. That's the first short point. The second one is on automatic entitlement as of right, that sort of debate that we had. And the thought was that I rode back from points in my skeleton argument. What I sought to say was that there is an entitlement prima facie to restitution in the same way there is in an ordinary unjust enrichment case, while accepting that, of course, that can be defeased by defences. That is not the same as saying, as I think my learned friend wishes to suggest, that there is a generalised discretion in the court to make restitution or not. That sounds much more like, I can put it this way, the bad old days of restitution, where it wasn't subject to the same structure and rigour that it is today.
Just pausing there, that's all on the hypothesis that the right dual basis is unjust enrichment. Do you say your submission holds good, whatever the dual basis?
Yes, because the derivation is the same cases. Unjust enrichment is the way of analysing that right as a dual basis. If that's not the way, the right way is the court's inherent jurisdiction, but that would still be subject to principles. It wouldn't be a roving jurisdiction, a roving discretion. which was why I had not thought I needed to engage in the question of which is the right juror basis. If unjust enrichment is the right analysis, I think the only point my learned friend ultimately took was there's no claim for time value in unjust enrichment. I of course accept that. I bear no scars from Prudential on this. It's true, Prudential says no time value in unjust enrichment. It does not, though, say you can't get it on any other basis. You can get it on the principal sum under section 35A. That's the ordinary way of doing it. And this then comes to, that's the second point, comes to the third point, whether you should do that, whether there should be a sum recognised in interest in my clients. Because I think the tenor of my learned friend's submissions were ultimately to accept this should take place today, not on a fictional basis in the past. And the question was then whether my clients ought to get interest on the principal sum that he would ultimately accept or could get.
I think he says, to that extent, you say it's not a matter of entitlement. The interest element is not a matter of entitlement.
Yes.
Is that right?
Is that what he said or what I said?
Is that what you accept?
I accept that under section 35A it's ultimately a question of discretion. My point though is that the discretion is not an untrammelled one. It's one that has to be applied by reference to the decided cases, the ones I showed the court this morning. And in particular, I suppose I'd say prima facie, Roger and Popplewell says, prima facie, absent special facts, one should get interest. I accept there are other points there that refer to that being not come what may, but one would still have to point to some reason why the general rule doesn't apply. And then the question is, what would that reason be? Why should HMRC not get interest? And I think the argument that was made, I think the only argument that was made, is something like HMRC ought to have paid this money sooner. Evonik has claimed for more than the amount paid. The amount should have been paid sooner, so HMRC shouldn't get interest on that money because it should have paid it anyway. That is what the judge thought. That's his analysis as I read it at the second judgment, paragraph 6, which is at page 45 of the bundle. Now, there is no meaningful, non-fictional sense in which the sums now claimed should have been paid in 2016 on the 5th. To the extent that sums ought to have been paid earlier, there is a specific legal regime to deal with what should happen where sums should have been paid sooner. That's the Senior Courts Act and the Finance Act. They recognise claims to interest on principal sums that by definition should have been paid sooner, because one always looks when, for example, under 35A, to determine when time should run from is when essentially the sum should have been paid. We know that those awards under those statutes are an adequate indemnity. It cannot be said that they are unjust without challenging Prudential or challenging Parliament's policy. And so I say it's simply not open to my learned friend to say his client should get some special dispensation because they wrongly sought summary judgment early and then got money. He shouldn't be able to walk around the statutes in that way, but that is what he's trying to do. If my client is not given interest, he gets nothing for the intervening period between money being paid and the set-aside. I've said that's inconsistent with Roger. What I've perhaps not stressed is that on Mr. Bremner's own case, it also seems like it would be unjust. But for Prudential, HMRC would have had an entitlement to Sempra interest on those sums. That's what follows from Sempra. That's what Goff and Jones used to say. After Sempra, you can't get the time value of the money. Sorry, after Prudential, you can't get the time value of the money. You're left to award with simple interest under section 35A. If we ought to be relieving parties, giving special dispensation to them because we're aggrieved with the Supreme Court's decision in Prudential, the same would apply to HMRC, and there ought to be some special dispensation paid. Now, if that's a bad argument, as I say it is a bad argument, it's a bad argument for Mr. Bremner as well. And it means then his client shouldn't get special dispensation. They should be not put in a different position to anyone who didn't bring an incorrect summary judgment application. My lady hypothesised a set-off today against Section 85 interest today and said you'd have to run Section 85 clock on. That would be true if the set-off is today, you would have to, but then that would show the injustice. If you don't give my client interest, then the money they paid back then, they get nothing for in terms of increasing the sums they're owed.
Sorry, you'll have to slow down a bit. I'm slightly lost you.
As I understood my lady's suggestion, and maybe it was not, that maybe I misunderstood it. My lady said, if you're doing set-off today under Section 85, you would have to run the clock on to today to give the up-to-date figures, not the figures in 2016. Correct. What I want to suggest is it would be unjust to then set off only the 6.4 million against that today, because then interest would have continued to run under Section 85, and they get the adequate indemnity, and we would get nothing for the 6.4 million that we paid in 2016 to today. And I think that's why the judge thought that he had to look at this in 2016, because otherwise you get that.
But that might suggest something about the interest rate that should be awarded under 35A, if you're right that you should get interest at all.
I can't get away from the fact it's discretionary, and I understand my learned friend to have rowed back from what I understood the position to be. I can't get away from that. The question would still be, why would the interest rate be different? And if the reason it should be different is that Section 85 gives a low rate of interest for a particular category of claim, and the court would have to think that that policy should be somehow read across to this instance of judgments being set aside. And we would say that's unprincipled.
The complaint against you is really about not just Section 85, but Section 35A as well.
That's the prudential point. So again, that would be, you'd have to then be, as it were, collaterally challenging the Supreme Court and saying it's not fair that we were deprived of our separate claims, which is precisely the thing that I say they shouldn't be allowed to do. If we are in the world of allocating in 2016, I don't think we get there. We're allocating today and deciding how it should be allocated in 2016. My Lord Justice Phillips said payroll can allocate first, and then there was a discussion about that. We said below, if that's the world we're in, you should allocate to capital, and we choose that. The court was sent on the 22nd of October, so last Friday, by Mr. Hayton of JHA, my learned friend solicitors, to Ms. Walker, who is, I believe, my Lord's clerk, a bundle of submissions before Mr. Justice Richards. At page 31 of those, in my skeleton argument, at paragraph 25(1), I'll just read it out. It's generally open to a debtor to apportion payments as it sees fit. The first time HMRC could apportion payments in 2016 was after the summary judgment orders were set aside. Brackets, I didn't say this here. We couldn't do this when the judgment was given because the order binds until set aside. So the first time we could do it was when the order is set aside. HMRC then made clear it wished to apportion them if quod non the payment arose to principal. I can't see how we could have done it earlier than that. If we could have done it earlier than that, it would be in our submissions to the court, the Supreme Court. And what we then said is, we don't need to claim this money back with interest because it will follow automatically. Now it's true, that doesn't say we're apportioning it to interest because we don't accept that entitlement, that analysis. But to the extent that's the right analysis, clearly what we meant must be we're allocating it in that way. Now my learned friend suggests, I think, in response to that, he was quickest to the punch because he did it in his application. In my respectful submission, that if that is what this turns on, whether the application notice was in before my skeleton argument, we're in a world of arbitrariness to the point of capriciousness. It cannot be HMRC's entitlements turn on that. If we are in that world, if I say caprice, I'll then rely on my submissions to the Supreme Court. But the fact that we end up in that world does suggest in my submission that something's wrong with the analysis. These problems don't arise on HMRC's case, which is why I commend it to the court. Subject to anything from behind, or your court would have those submissions.
Could I just ask, do you want to say anything about the faintly advanced submission that there might be a different rate of interest for the government in relation to government's cost of borrowing for Section 35A purposes on your notional restitutionary claim, or your actual restitutionary claim, that which would apply as per the Supreme Court on a borrowing basis to a commercial taxpayer.
Can I take a moment to consider that? We have no evidence on it, so I cannot come to the court and say, here's what our rate of interest is or should be because of that. It's not a point that's ever been taken against us, and I understood from the submissions that it was agreed this way. I understand that my learned friend says that wasn't his intention. That's why we never put anything in.
Well, the judge below certainly seems to me to have proceeded on the basis that the two rates would be the same.
Precisely, the whole dialectic
Which is,
presupposes that, which is why
that's how it explains it comes down to allocation between principal and interest.
yes. So that is what explains why we have no evidence in answer. I took it that my lord's question was, do I have anything else to say on that? I understand there are other claims in the GLO, including with that, where we have got Section 35A interest when it's been paid back, but that's not Evonik, and I can see Evonik would say we shouldn't be bound by agreements with them. That has been the practice in other claims, but I can't seek to.
You simply say it doesn't arise because everybody proceeded on the basis that the same rate should apply.
Yes,
If it applies, if there is a Section 35A rate to be applied at all.
that is my submission.
Can I ask
fine.
you, sorry, can I ask you this? It seems to me that there's a debtor who wrongly, mistakenly pays his creditor early, perhaps by mistake or misled or whatever, can either say, right, well, I'll wait till position is fully determined and seek to have this sum credited in the calculation, or he can say, I made this payment by mistake, give it back. You didn't do the latter. What you've done is the former. And it seems to me the former is seeking a credit on whatever basis. The latter is a claim for restitution. I don't think on that analysis you haven't made a claim for restitution, have you? Restitution, sorry, just to say restitution is claiming payment back.
And let me try, I'm not sure this is going to be responsive. I say we did make a claim for restitution when we said we're entitled to this, we're entitled to it by motion rather than claim form, and it should then be set off. So we did raise that the first time that the remitter goes before the judge. And all we were saying is we now want to set this off in this way. I say that is a sufficient claim. Your lordship says, though, you say that one or two things can happen. So in that world, we are in the world of saying we're making a claim. As soon as it were, we thought it was appropriate to do so. Maybe we could have said it to the Supreme Court. If we could have said it to the Supreme Court, then it does seem, I've already made this submission, so I don't want to draw on it, again, capricious to think HMRC's position can vary as to whether they say it to the Supreme Court or Mr. Justice Richards simply because of determinations on completely separate causes of action. That is the logic of my learned friend's case, and it's the logic if, with, as your lordship's proposing, although not necessarily endorsing, one approaches it in that way as simply a question of allocation. As I say, I wasn't sure if that was going to be responsive, so but I think that is an answer.
Anything else? Well, thank you all very much. We will reserve our judgment. We'll send it to you in draft in the usual way for administrative or other non-controversial factual corrections, no re-arguing. If you could, when you provide those, also provide either an agreed order or where you disagree or rival contentions, we'll determine those on paper. We always say, but it is important, you're well aware of the embargo on the draft judgment, and it is very important that everybody understands, including those who aren't in this room, how important it is to keep to that and what the sanctions are for breaching it. Thank you very much.
Court rise if able.